Imagine this. A father passes away at 71. He was organised. He had a will, neatly signed, sitting in a folder in his desk drawer, right where he told his daughter it would be. The family gathers, grieves, and then his daughter takes that will to the bank to access his checking account so she can pay the mortgage on his house. And the bank says no, not yet, not until the court says so. That court part turns into a process that takes 14 months. 14 months of frozen accounts, legal fees, court filings, letters to creditors, an appraisal on the house, and a strange notice published in the local newspaper announcing to the world that her father has died and inviting anyone he owed money to come forward. By the end, the family has spent tens of thousands of dollars, the house sat in limbo for over a year, and the daughter, who was already grieving, spent more than a year doing paperwork for a court she never expected to deal with. Here's the part that shocks most people. Nothing went wrong in that story. Nobody contested the will. There was no family fight, no missing document, no fraud. That was probate working exactly the way it's designed to work. And that's the nightmare nobody warns you about. It's not that probate breaks, it's that even when it works perfectly, it can be slow, expensive, public, and exhausting, and the will your loved one so carefully signed doesn't prevent any of it. If you're watching this, chances are you either have aging parents, or you're doing your own planning, or someone you love has recently passed, and you've just heard the word probate for the first time. Whatever brought you here, this matters, because probate touches almost every American family eventually, and most families walk into it completely blind. Now, before we go any further, let me be clear about something important. I'm not an attorney, and this video is general education, not legal advice. Probate rules are different in every single state. The timelines, the costs, the thresholds, the paperwork, all of it varies. So think of this as the background knowledge that helps you ask smarter questions when you sit down with a licensed estate planning attorney in your state. That conversation is where real decisions should happen. This video is where understanding begins. By the end of the next few minutes, you're going to understand what probate actually is, why it takes so long and costs so much even when nothing goes wrong, which of your assets are headed for probate right now without you realizing it, and the handful of tools families use to keep property out of the process entirely. If that sounds useful, take 1 second to subscribe, because this channel exists to help you protect your family from exactly these kinds of expensive surprises. Now let's pull back the curtain. Let's start with the basics, because probate is one of those words everyone has heard and almost nobody can define. Probate is simply the court-supervised process of settling a deceased person's estate. When someone dies, somebody has to make sure their debts get paid, their taxes get filed, and whatever is left gets handed to the right people. Probate is the legal system's way of supervising that. A judge, or a court clerk, oversees the process to make sure it's done properly. Here's how it generally unfolds. First, someone, usually the person named as executor in the will, files a petition with the probate court in the county where the deceased person lived. They submit the will, if there is one, and a death certificate. The court then has to validate the will, meaning it confirms the document is genuine and was properly signed. Once that happens, the court officially appoints the executor and gives them a document, often called letters testamentary, which is essentially a permission slip that says this person now has legal authority to act for the estate. And this is a detail that stuns people. Until the executor has that court-issued authority, they generally can't do much of anything. The bank won't hand over the money. The brokerage won't transfer the stocks. The title company won't let the house be sold. That's why the daughter in our opening story got turned away at the bank. The will named her, yes, but a will by itself is just a piece of paper making a request. The court is what gives it power. After the executor is appointed, the real work begins. They have to create an inventory of everything the person owned, every account, every vehicle, the house, sometimes even furniture and jewellery, often with formal appraisals. They have to notify known creditors and in most states, publish a notice in a newspaper so unknown creditors can come forward. Then there's a waiting period, often several months, during which creditors are allowed to file claims. The executor pays valid debts, files the person's final income tax return, handles any estate tax filings if the estate is large enough, and only then, after the court is satisfied everything has been handled, can the remaining assets be distributed to the heirs. And if the person died without a will at all, the process still happens. It's just that state law, not the family, decides who inherits, using what are called intestacy rules. So probate isn't a punishment, and it isn't rare. It's the default. Unless your assets are specifically structured to bypass it, probate is where they're going. Consider a situation like this. Imagine a widow, let's call her Carol, who passes away owning a paid-off home, a checking account, a CD at her local bank, and an old brokerage account. She has 3 adult children, they all get along beautifully, and she left a simple, valid will splitting everything equally. Sounds easy, right? Her oldest son is the executor. He files the petition, and it takes 6 weeks just to get the first hearing on the court's calendar. Then the letters testamentary arrive, and he starts calling banks, each one with its own forms, its own processing times, its own requirements for certified copies of the death certificate. The house needs a formal appraisal for the inventory. The creditor notice runs in the newspaper, and the state requires a 4-month window for claims, so nothing can be finalized before then. A medical bill from Carol's last hospital stay shows up in month 3 and has to be reviewed and paid. Her final tax return can't be filed until the new year. The brokerage account, it turns out, was never given beneficiary designations, so it has to flow through the court too. 11 months later, the estate finally closes. Nobody fought, nobody sued. The attorney and court costs still consumed a meaningful slice of the estate. The house couldn't be sold for most of a year, and Carol's son spent hundreds of hours on hold, at the courthouse, and at the post office mailing certified documents. That's a smooth probate. Now imagine one where a sibling disputes the will, or the deceased owned a cabin in another state, and you can see how families end up in probate for 2, 3, even 4 years. Now let's talk honestly about why probate earns the word nightmare, because it comes down to 4 things: time, money, publicity, and stress. Time first. Even a simple, uncontested probate commonly takes somewhere between 6 months and a year and a half, depending on the state and the county. Courts have backlogs. Creditor claim periods are set by law and can't be rushed. Every step tends to wait on the step before it, and during much of that time, assets are effectively frozen. The family may not be able to sell the house, access investment accounts, or distribute a dime, even to heirs who desperately need the money. Second, money. Probate has layers of cost. There are court filing fees, there are appraisal fees, there are executor fees, since the executor is legally entitled to compensation for their work. And most significantly, there are attorney fees, because most executors wisely hire a probate attorney to guide them. In some states, attorney and executor fees are set by statute as a percentage of the estate's gross value. And notice that word, gross. In those states, the fee can be calculated on the full value of the house before subtracting the mortgage. A home worth $600,000 with a $400 mortgage may generate fees based on the full $600,000. All told, it's common for probate costs to consume roughly 3 to 7% of an estate, and complicated estates can burn far more. On a $500,000 estate, that can easily mean $15,000 to $35,000 that never reaches the family. Third, and this one truly surprises people, probate is public. The will gets filed with the court, and in most places, anyone can go read it. The inventory of assets, the debts, the names of the heirs, what each person received, much of it becomes a public record. There are companies and individuals who monitor probate filings specifically to market to grieving families, and heirs who've just inherited money sometimes find themselves targets for scams and aggressive solicitations. Your family's private financial life, laid open at the exact moment they're most vulnerable. And fourth, there's the human cost. The executor is almost always a grieving spouse or child, and probate hands them a part-time job that lasts a year. Deadlines, court forms, creditor letters, tax filings, all while they're mourning. And here's the multiplier that catches snowbirds and vacation homeowners. Probate happens where real estate sits. If someone lives in Illinois but owns a condo in Florida and a cabin in Wisconsin, the family may face separate probate proceedings in multiple states, each with its own attorney and its own costs. It's called ancillary probate, and it turns one nightmare into two or three. So here's the good news, and it's genuinely good. Probate is largely optional if you plan ahead. The key insight is this: probate only applies to assets that are titled in the deceased person's name alone, with no beneficiary attached. Anything with a built-in mechanism for transferring at death skips the court entirely. Let's walk through those mechanisms. First, beneficiary designations. Retirement accounts like 401ks and IRAs, life insurance policies, and annuities all let you name a beneficiary. When you die, those assets pay directly to that person. No court, no waiting, no probate. This is why keeping beneficiary forms up to date is one of the most powerful and most neglected pieces of estate planning in America. Second, payable-on-death and transfer-on-death designations. Most banks let you add a payable-on-death or POD beneficiary to a checking account, savings account, or CD, usually with one free form. Brokerage accounts offer the same thing, called transfer-on-death or TOD. The named person simply shows up with a death certificate and the asset transfers. Some states even allow transfer-on-death deeds for real estate, letting a home pass directly to a named beneficiary without probate, though not every state offers this, which is exactly why state-specific advice matters. Third, joint ownership with rights of survivorship. When two people own an asset jointly with survivorship rights, and one dies, the survivor automatically owns the whole thing. This is common between spouses. It works, but it has real trade-offs and risks we'll touch on in a moment. And fourth, the heavyweight tool, the revocable living trust. With a living trust, you create a legal container during your lifetime, retitle your major assets into it, and name yourself as trustee so you keep total control while you're alive. You can spend, sell, change, or cancel anything, anytime. But when you pass away, the person you named as successor trustee simply steps in and distributes the assets according to your instructions, privately, without court involvement, often in weeks or months instead of years. The house, the accounts, the investments, if they're properly titled in the trust, they never touch probate. Trusts cost more to set up than a simple will, and they only work if you actually fund them by retitling your assets. But for many families, especially those with real estate or property in more than one state, they're the single most effective probate avoidance tool that exists. And one more piece of good news. Most states have simplified small estate procedures, often a simple affidavit, for estates under a certain value. The thresholds vary wildly from state to state, from just a few $1,000s to well into six figures. But if the probate assets are modest enough, the family may skip the full process altogether. Now let's clear away the myths, because bad assumptions cause most probate nightmares. Myth number 1, the big one. Having a will avoids probate. It does not. A will is essentially an instruction letter to the probate court. It makes probate smoother, and it makes sure your wishes control the outcome. But the will itself is the ticket into probate, not the way around it. Myth number 2. My spouse automatically gets everything. Not necessarily. If assets are jointly owned or have your spouse as beneficiary, yes. But an account or property titled in one spouse's name alone can absolutely end up in probate, and in some states, intestacy laws can even split assets between a surviving spouse and children if there's no will. Myth number 3. I'm not wealthy enough to worry about this. If you own a home, you likely have a six-figure estate, whether it feels that way or not, and homes are exactly the asset that drags families into full probate. Myth number 4. I'll just add my adult child to my deed and my bank accounts. This one sounds clever and backfires constantly. The moment your child is a co-owner, your home is exposed to their creditors, their divorce, their lawsuits, and their bankruptcy. You can also create gift tax complications and cost your child a valuable tax benefit called the step-up in basis, potentially handing them a large capital gains bill later. There are almost always cleaner tools for the same goal. And myth number 5. I did my estate plan years ago, so I'm done. Beneficiary designations go stale. People forget to update forms after divorces, deaths, and remarriages, and an outdated beneficiary form generally beats whatever your will says. Families have watched retirement accounts pay out to an ex-spouse because of a form nobody looked at in 20 years. So what do you actually do with all this? Here's a practical path forward, in plain English. Start by making a simple list of everything you own: home, vehicles, bank accounts, retirement accounts, brokerage accounts, life insurance, and next to each one, write down how it's titled and whether it has a beneficiary. That single exercise will show you, in black and white, which assets are currently headed for probate. Next, contact your bank and your brokerage and ask about adding payable-on-death or transfer-on-death beneficiaries. It's usually a free form and takes minutes. Then, pull the beneficiary forms on your retirement accounts and life insurance and confirm every name is current, and consider adding contingent beneficiaries as backups. After that, ask an estate planning attorney in your state 2 specific questions. Does my state offer a transfer-on-death deed for real estate? And given my situation, would a revocable living trust make sense for my family? Those 2 questions alone will surface most of your best options. If you already have a trust, verify it's actually funded, meaning your house and major accounts are truly titled in the trust's name, because an empty trust protects nothing. And finally, tell your family where your documents are. The best plan in the world fails if nobody can find it. None of this has to happen in one weekend, but every single item you check off shrinks the burden your family will carry someday. Here's the heart of it. Probate isn't evil, and the people working in probate courts aren't villains. But the process was built for oversight, not for grieving families, and every month it drags on, every dollar it consumes, every private detail it publishes, is a cost your loved ones pay at the worst possible moment of their lives. The beautiful truth is that this is one of the few nightmares in life you can genuinely prevent. A few forms, a few conversations, maybe a trust, small acts of love, done now, while everything is calm. That's really what estate planning is. It's not about documents. It's about making sure that when your family is grieving, the only thing they have to carry is the grief. If this video opened your eyes, please give it a like and subscribe, because every week we break down the money and estate topics that protect families like yours. And one final important reminder: everything in this video is general education, not legal advice. Probate rules, costs, timelines, and estate laws vary from state to state, and your situation is unique. Before you make any decisions, sit down with a licensed estate planning attorney in your state and let them tailor a plan to your family. Thank you for spending this time with me. Now go take that first small step. Your family is worth it.